And I felt that was obviously frivolous because Mr. Harris should know he's an attorney. He knows he knows the difference between a cost and an attorney's fee.
Page 4, A781255, Kurt Harris versus Ernest Del Casal.
Morning, Judge Jerry. Kurt Harris on behalf of the plaintiffs.
Good morning, Judge. Alda Anderson on behalf of Mr. Franklin.
And Attorney Al Needham here for Defendant Del Casal.
This is plaintiff's motion and application for attorney's fees, interest, and costs. Plaintiff, go ahead.
Well, thank you, Your Honor. And just to bring Your Honor up to speed, the hearing actually was held on January 5th of 2023. At that time, the interest was granted and the cost had previously been granted by Judge Jones. At that point, there was the court granted leave to me to supplement my motion to set forth the Brunzell factors on behalf of Carrie Doyle, who was co-counsel in the case. And so I did the supplement of that. And this hearing today is for those fees that were incurred by Mr. Doyle, which was $8,640. We submitted the Brunzell affidavit with regard to Mr. Doyle only. I did not see in either of the oppositions any opposition with regard to Mr. Doyle's experience, the fees, the amounts that were charged, or that the result wasn't a good result on behalf of the plaintiff. So with that, Your Honor, we specifically are requesting Mr. Doyle's fees be granted in the amount of $8,640. Thank you, Your Honor.
Opposition?
Yes, Your Honor. Thank you. This is Attorney Needham for Defendant Del Casal. This is a supplemental motion for attorney's fees. The original motion for attorney's fees was filed back in October of last year, and it was strictly filed on behalf of Mr. Harris for himself. Plaintiff was seeking attorney's fees for himself, not Attorney Doyle. What Mr. Harris did that same day, on October 14th, is he filed a memorandum of costs on that day, which is a one-page document, but he attempted to assert Carrie Doyle's invoice, which is what the subject matter of this hearing is today. He tried to submit that as part of a cost. And as we all know, that an attorney's fee is not a cost, but I was required then to file a really prompt motion to retax costs. You have to file those, I think it's within 3 days. You have to file a motion to retax costs under the statute, and if you don't do that, they're pretty much automatically granted. So that's the predicament that Mr. Harris put the defendants under. So I filed a motion to retax, and Judge Jones, quickly rejected that as a cost because that's an attorney's fees, Mr. Harris. It's not a cost. But I argue in our opposition that Mr. Harris did that because he was trying to take advantage of defendants, by slipping that in or sneaking that in as a cost. So that's why we're here today. Months and months later, here we are now on February 14th. This is 4 months since the judgment. So that's why we're here, and that's what my concern is, and that's why we filed a counter motion for attorney's fees. Mr. Harris seems to believe that attorney's fees are an entitlement. They're not an entitlement. They're discretionary. My first argument, having said that, Your Honor, the background is that I believe this supplemental motion is really questionable. The question is filing this as a supplement, is this proper? I feel that we're just basically swapping an attorney and a brand new attorney, Mr. Doyle. This is essentially a new motion for attorney's fees, is the way I look at it. I don't think the supplemental process, especially given the background of the improper maneuver trying to label Mr. Doyle as a cost, that's the background here. So just to now try to correct all that process by calling a supplement, it raised an issue whether that's even a proper method to do this, because we know that you're supposed to file a motion for attorney's fees properly, and you're supposed to file it within 21 days after the judgment. And here we're in February now. So in regard to the motion itself, motion for attorney's fees, that was heard in January. And the reason why it was heard in January, even though it was filed in October of 14th, the original motion, is because Mr. Harris didn't pursue the hearing date. So he, for some reason, didn't get a hearing date on it. And I'm not sure if that was part of his strategies or what, but we eventually heard that on January, I think it was 5th, Your Honor. And the Judge Jones quickly denied Mr. Harris's motion for attorney's fees for himself. So his motion was essentially denied. So having said that, and that was took a lot of time to have to oppose that. That's why I filed a counter motion. I felt the labeling as a cost to make me file a motion to retax was obviously frivolous, Your Honor, and that's the standard. It's something obviously frivolous. Well, we all know attorney's fees are not costs under the statute, and that's the cost statute, the memorandum process. I've never seen an attorney do that. You know, that's not a cost, and so defendant had to go through several hours to deal with that proceeding, and I cert $2,500 for that, given the fact it was an obvious frivolous maneuver, and then having to oppose this motion for attorney's fees, the original one that Mr. Harris filed for himself, is personal time. And, you know, for Your Honor, for 20 years, the Nevada Supreme Court has said litigants don't get attorney's fees for their personal time. It's pretty well understood. So that took a lot of hours to have to oppose that. And I felt that was obviously frivolous because Mr. Harris should know he's an attorney. He knows he knows the difference between a cost and an attorney's fee. So I felt that I asked for $5,000 of time for having to oppose all that. And so that's the basis of my counter motion, Your Honor. The defense was not frivolous in this case. You know, and I explained that in the papers. So I don't know what basis Mr. Harris has to even get attorney's fees. We have to have a basis first, and there was nothing frivolous about the defense here. And on that note, Your Honor, I appreciate your time. Thank you.
Thank you. Reply? Did you want to say anything?
Yeah, Judge, I just want to, Mr. Needham said everything very succinctly and clearly, but I just want to piggyback for a brief moment on what he said, that initially Mr. Harris filed the other attorney's fees, he put it under cost. And now he's filing a supplemental motion. Supplemental motion suggests that a motion was initially filed for that, and now you're adding to it. If there was no initial motion for Mr. Doyle's fees, there can't be a supplemental motion for his fees. So, as Mr. Needham said, it's totally untimely, and therefore it should be denied. Additionally, and I think we get to I think it's section 18.010 as to there were two defendants in this case, and together they recovered over $20,000, and under the law, if you recover over $20,000, you're not entitled to attorney's fees. So just piggybacking on Mr. Needham's.
Reply?
Thank you so much, Your Honor. May it please the court one more time. The defendants are still arguing prevailing party. That's already been ruled on. Judge Jones clearly stated that I was the prevailing party and made that ruling. They continue to re-argue the motion, which I don't believe counsel's read my initial motion, which had Mr. Doyle's attorney's fees therein included. The only deficiency was a lack of a Brunzell affidavit on behalf of Mr. Doyle. Again, Judge Jones ruled on it. Judge Jones granted leave pursuant to NRCP 15D to supplement the paperwork with a Brunzell affidavit on behalf of Mr. Doyle, which I have done. There has been no opposition that you have heard here today with regard to any of Mr. Doyle's fees or the outcome that is admissible at this time, given the motion that was filed and the leave that was granted by the court. And so we just asked that Mr. Doyle's fees be granted in the amount of $8,640. With regard to much of Mr. Needham's argument, I'm unclear on where that was going, but costs were previously awarded by Judge Jones in the amount of $6,000 plus. I can't remember the exact number, and costs have been ruled on, and they were awarded to me. So this is merely for the attorney's fees portion of Mr. Doyle's attorney's fees. which were requested in the motion for attorney's fees. Thank you, Your Honor.
I'm going to deny defense motion for attorney's fees, and I'm going to grant plaintiff's motions for attorney's fees, but I'm going to reduce it to $2,500. I think that's appropriate under Brunzell because of the outcome. I think that's as much as
And what is the amount, Judge? I'm sorry, I did.
2,500.
2,500.
So that'll be the order. The plaintiff will prepare an order. Thank you.
Thank you, Judge.
Page